The SEC case is as exciting as ever, with even SEC commissioners defending crypto. Will this help Ripple win the case? And how could attorney Jeremy Hogan's newest comments help to overthrow the SEC? Stay tuned till the end of the video to find out. But first, we are giving away $500 at the end of the month to one random subscriber to start on their XRP journey. All you need to do is to like the video, subscribe and comment your thoughts on XRP in the comments section. Welcome back, XRP Army. Let's grow the XRP Lab community by pressing the like button and subscribe. As we all know, the Securities and Exchange Commission, SEC, continues to pursue cryptocurrencies. The following statement, given by a high-ranking SEC commissioner, deserves to be mentioned. In the opinion of a commissioner of the United States Securities and Exchange Commission, SEC, authentic decentralized efforts constitute an obstacle to cryptocurrency regulation. When a result, the commissioner noted that decentralized finance carries within itself inherently some ability to self-regulate, and that we must take that into consideration as we design a regulatory system. Hester Peirce, commissioner of the Securities and Exchange Commission, recently spoke with Yahoo Finance on the regulation of cryptocurrencies, which was later made public online. Among members of the crypto community, Peirce is known to as Crypto Mom because of her great knowledge of and support for the cryptocurrency industry. They wanted to know if the Securities and Exchange Commission was having trouble keeping up with the rapid developments in the cryptocurrency industry and protocols, which are developing and changing at a dizzying pace on a daily basis. She answered yes to my question. People should not be under the impression that the SEC can only concentrate on a particular problem at a given time. A significant amount of resources are available to the SEC, which enables it to pursue a big number of targets at the same time. In a similar spirit, Gary Gensler, chairman of the Securities and Exchange Commission, noted that many systems that purported to be decentralized were actually centralized. Recently, he wrote to Senator Elizabeth Warren to alert her that many platforms are only decentralized in name, emphasizing the fact that there is a user agreement. Aside from that, he asserted that many of the tokens sold on cryptocurrency exchanges are basically securities, and he told Congress that the market needs further regulation. Peirce continued by stating the following: "It is integrated into decentralized finance from the beginning with the ability to self-regulate built in from the beginning of the process. And I feel that it is something that should be taken into consideration when developing a regulatory framework. As a commissioner at the Securities and Exchange Commission, an important part of my job is protecting investors from the fraudsters who can cause them so much harm. The SEC can and does play a role in providing investors with tools they can use to assess whether a particular investment or investment strategy makes sense for them. We require that issuers provide honest disclosures about securities so that investors can gauge whether an investment is right for them. Moreover, we offer general educational materials that help investors to appreciate the role investments can play in their families' lives, to spot frauds, to understand different types of investment products, to appreciate the value of portfolio diversification, and to ask good questions about whether a particular investment or investment professional is right for them. Respect for individual liberty is a core American value. People have the presumptive right to make choices that affect themselves and their families, and government should be wary of overriding those choices. All Americans deserve that respect in their financial lives as they do in every other aspect of their lives. Regulators have a role to play, but that role should always be carried out with humility and a realization that investors have a right to make their own decisions, regardless of what regulators think of them. Interesting, isn't it? So, what do you think this means for the future of the SEC versus Ripple case? Let us know in the comments section down below. Ripple has submitted a formal response to the SEC's most severe threat to date in order to oppose it. You may find the response here. As part of its motion, Ripple is seeking that the court compel the firm to search for and produce video and audio recordings of its meetings in which it discusses matters that are critical to the litigation's arguments. As part of a request submitted earlier this month, the SEC said that Ripple had employed an improper search strategy that had missed out on significant evidence. The SEC outlined the flaws and stated that it is important that the defendants provide the SEC with the relevant audio and visual records. According to a news release, the SEC is seeking evidence that the individual defendants and key employees were aware that XRP may have constituted a security since they advertised the digital asset as an investment contract. In the agency's opinion, this is the most convincing case they have against Ripple. Ripple, on the other hand, argued that the SEC's request should be denied, and he provided 3 reasons why the tapes in question should not be made public. Also, make sure to write your thoughts on these latest news regarding the Ripple versus SEC case in the comments section. Attorney Jeremy Hogan has also weighed in on the debate, expressing his expectations for the judge's next step in light of the importance of the tapes for the SEC's case and the limited time available for fact discovery in the litigation. Hogan is representing the SEC in this matter. Whatever it is that the SEC is referring to, I have a feeling that those recordings will form the backbone of the SEC case, and that is why that whether it is able to gain access to more recordings is very important to the case, and, so far, things are not looking good for Ripple on that front. Mr. Hogan reminded the audience that the judge has a lot of discretion in discovery conflicts, so it's hard to predict what the outcome will be. My instinct is that she is going to want to allow the SEC to be able to dig deeper further into Ripple's sandbox, and that feeling just comes from her prior rulings in this case. The problem is time, he continued, adding that the discovery cutoff is coming in early November. That might lead to a denial of the SEC's motion, but my best guess would be a limited granting of the motion that would allow the SEC to get more recordings, but in a limited way. Furthermore, the SEC's assertion that the unproduced recordings have a direct impact on whether Ripple's offers and sales of XRP are investment contracts, and therefore securities under Howey, is pure conjecture on the part of Ripple. According to the SEC, the answer went on to say, the response from Ripple stated that the SEC's request is, assuming arguenda that any unproduced recordings pertain to that issue, which is purely speculative. The SEC's request remains of prior discovery concerning that topic because of prior discovery concerning that topic, which is purely speculative, and that the company has produced more than 170,000 documents and 1 million pages that hit on responsive search terms, including meeting agendas, slide deck presentations with detailed speaker notes, summaries and discussions of telecommunicators. By submitting 2 documents and an email chain to the impending in-camera examination of the cryptocurrency lawsuit of the century, Ripple has recently scored a significant victory in what has been dubbed the cryptocurrency lawsuit of the century. Ripple has been dubbed the cryptocurrency lawsuit of the century because of its involvement in the cryptocurrency industry. According to the email chain, the defendants are in discussions with a third party about which they believe they have received advice from the SEC to assess its digital asset in accordance with the framework laid out in Director William Hinman's June 14, 2018 speech, which is the subject of the email chain. During the course of this lawsuit, the judge will analyze any material that may indicate that the SEC adopted Hinman's statements as policy. Because the agency has said for months that the speech was only a personal opinion, this may be a severe blow to the agency's credibility in court. The defendants have gathered a considerable quantity of evidence in order to support the summary judgment on Ripple's fair notice defense, which was used in the decision. To support its argument, the SEC appears to be relying on the claim that XRP was sold and promoted as an investment contract, and hence as a security under the Howey test. What do you think about Pierce's comments on the SEC case? Do you think they will help Ripple win the case? Let us know in the comment section. If you want to continue to know about XRP, we have got 2 videos waiting for you on the end screen to check out. Make sure to subscribe and give us a thumbs up. Thank you so much for watching. See you in the next video. Kindly note that prices of cryptocurrencies frequently change, so by the time you watch this video, it might have changed to a whole new value. The information provided in this video does not constitute investment advice, financial advice, trading advice, or any other sort of advice, and you should not treat any of the content as such. The content in this video is for educational purposes only and hence should not be considered financial advice. Do conduct your due diligence and consult your financial advisor before making any investment decisions.